everyone.
On the topic.
Hi, thank you so much for being here. My name is Christina Michelakaki. I'm a policy fellow for global privacy at the Future of Privacy Forum, a non-profit think tank. And today I will be moderating this amazing panel, discussing on data protection by design and by default, and the uptake of privacy-enhancing technologies. So I would like to start with some brief introductions of our amazing speakers. So first, we have Jaap-Henk Hoepman, Associate Professor of Privacy Enhancing Protocols and Privacy by Design at the Radboud University in Nijmegen, Associate Professor in IT Law in the University of Groningen, and Guest Professor at PRISEC in Sweden. Jaap focuses on privacy by design, privacy-friendly protocols, identity management, and the impact of new technologies. Thank you very much, Jaap. Then we have Cameron Russell, the primary privacy advisor on all global payments privacy matters at eBay. Cameron has extensive experience on building data privacy and security into large and complex programs and has a background on emerging technologies. Thank you very much, Cameron. Then we have Marit Hansen, the Deputy State Commissioner for Data Protection in Schleswig-Holstein. Good. Who has been significantly shaping and advancing the approach of data protection through privacy by design. She focuses on pets and data security, and in 2007, she was appointed as an expert to the Privacy and Technology Working Group of ENISA. Thank you very much, Marit. And last but not least, we have Stefano Leucci, a legal and technological expert at the European Data Protection Supervisor. Stefano has been the author of several issues of the EDPS Tech Dispatch and leads the Tech Sonar, an EDPS initiative that aims to better anticipate future and emerging technologies. Stefano has a diversified experience as a DPO, both in public and private organizations. Thank you very much, Stefano. So, as I said before, today's panel is essentially about Article 25 GDPR. So this article encompasses two distinct obligations. So first, the data controller has to implement appropriate technical and organizational measures in order to safeguard all data protection principles, as we know them in Article 5 of the GDPR, and safeguard all data subjects' rights and freedoms. And all this by design. This is a really broad obligation. And then the second obligation is a bit more narrow. So it's data protection by default. And here the controller has to implement appropriate technical and organizational measures again in order to ensure that by default, only data, personal data necessary for its specific purpose are being processed. So that said, I think it's the perfect moment to flag, if you haven't already seen it, that the Future of Privacy Forum has launched just last week a new report on the enforcement of Article 25 of the GDPR. And you can find physical copies here as well. So this report was co-authored by Sebastião Barros-Veil, my former colleague, and myself. And we have included 92 cases from national data protection authorities and national court rulings, enforcing Article 25 of the GDPR. So I guess you can find a lot of interesting things in there, and we will be discussing a lot more about it later. But for now, I think that I want to just flag two main conclusions that are really interesting to see, and it will be a nice bridge to our later conversation. So first, I would like to say that we found that the DPAs interpret Article 25 GDPR divergently. And this is really obvious when it comes to the preventive nature of Article 25 GDPR. And what do I mean about that? I will give concrete examples. So, in the case of Austria, for example, we had a citizen complaining that a public repository did not implement sufficient measures, and therefore, in the hypothetical case of a data leak, his right to secrecy would be violated. Here, the Austrian DPA said that since no data leak had actually occurred, so no principle had been violated, and no data subject right had been violated, the citizen only had a subjective legal claim which could not be accepted. So we see here the Austrian DPA not accepting this preventive nature of Article 25 GDPR. On the other extreme, we have the Belgian DPA. Here we have a case in which a Belgian public authority opted for Microsoft's services and products. And basically, it required citizens to create a Microsoft account in order to access tax-related documents. And here, the Belgian DPA essentially said that even if no processing had occurred, because the citizen didn't want to create a Microsoft account, even if so no data principle had been violated, no data subject had been violated, Article 25 can still be applied. And this is what the Irish DPC said in the context of Instagram services and the processing of children's personal data. Here, the Irish DPC said that Article 25 reflects to possible harm, to exposure to danger. So we don't need to have exploitation of children. We need to have just a risk for Article 25 GDPR to be triggered. So I think this is a really interesting finding, and I'm gonna jump to the final one, which may sound a bit more simplistic if you compare it to what I just said, but I think it's quite interesting also and a bit overarching. So it has to do with, like, I'll just put it in one phrase. As Levi Grave has said, Article 25 GDPR is capable of a real bite. And this finding, substantiated by all the decisions that we found, is very crucial. And the reason is because it contradicts claims that say that this article is too vague or too broad to be applied in individual cases, because we have found more than 160 cases enforcing Article 25 GDPR. So that is all you're going to hear from me today. As I said, there are physical copies over there, so please feel free to grab one. And I'm going to go straight to our panel discussion now. So let me start with Jaap. So DPAs are yet to further develop their common views on pets in online environments. This is one of the findings of the report. So in light of this, do you think that we should aim for a clearer framework on what pets or other technical measures are deemed as appropriate? So in other words, do we need clear guidance from EU regulators to generate confidence and to finally see controllers applying pets in different settings, sectors, etc.?
Thank you for your question, and thank you for this difficult question, actually. Because on the one hand, you would definitely want to have clear guidance on, how to really satisfy the requirements of Article 25 and how to do data protection by design in concrete cases. But this is exactly the problem, because it's often the case that the kind of things that you can or want to do or should do are very context dependent. And I think even in your report you have examples where in certain cases a login with only a username password is maybe good enough, and in other cases you really need to do two-factor authentication. And this is just a very simple example. But as soon as you want to say something like you have to apply maybe concrete PETs like homomorphic encryption or secure multi-party computation, zero knowledge proofs, that kind of stuff, that is so super context dependent. And in certain cases, it would be totally not useful to do that kind of stuff. So on the one hand, you want guidance, but then the guidance should be very contextual. And secondly, what I find somewhat surprising is that in many of these discussions, we are focusing very much on very concrete privacy-enhancing technologies. And we seem to be forgetting that there's actually a step before that, which is the design step, where you start thinking about what kind of system do you want to design, what are the functional requirements, and what are the non-functional requirements, what are the privacy and data protection requirements, and how can we sort of like by rethinking the initial design, maybe design a system that is much more privacy friendly to begin with. So, and this is something, of course, that I've been writing about a lot with my privacy design strategies. And I think one of the things that we are currently thinking about as a sort of way to fill this sort of gap between, on the one hand, the general design strategies on the one hand and the privacy enhancing technologies on the other hand, is thinking about guidance in the form of design patterns, where you have, and there's some catalogs out there, but I'll admit they're not mature yet. They're not really usable yet. But I think those things could be a very interesting. Those design patterns could be like a good encapsulation of, preferred solutions in specific context, because that's the whole idea of a design pattern, is to describe a specific context where a particular solution would be applicable. So I think that is something that is might be helpful, but this is something that if you want to do that, you actually have to do that together with industry. And then this is a second maybe gripe of mine, is that what I notice when talking about data protection by design, when talking about my design strategies, if I look at where this stuff is being used, or at least where it is received, I notice that most of the times it's by DPOs, it's at the policy layer. And what is somewhat surprising to me, at least, and I would love to hear counterexamples, I would love actually to be proven wrong here, it almost seems like the legal and the policy field is much more engaged with data protection by design than the actual engineers that we should be doing that. So one of the things that I would love to think about and invite you to approach me afterwards, or maybe discuss here, is how to bridge that gap and really get that across and used at the engineering stage. Thanks.
Thank you very much. Very useful remarks, and I found your papers really interesting on the design strategies. So yes, thank you very much. And I think with that we can easily go to the next question to Cameron. So can you now elaborate on what specific PETs and strategies eBay has been implementing to ensure compliance with the GDPR and especially Article 25? And is it challenging to ensure that the PETs that you're choosing are the best existing technologies that exist in the market?
Yes, thank you. And thank you to FPF for organizing and the opportunity to be here. Hopefully, Jaap-Henk's comments, I can build off those, I think. This might segue nicely. But to answer your first question in terms of some tangible examples that eBay is working on in terms of PETs. One simple example is just intermediated member-to-member messaging capability. So this is a simple example, but I think provides high privacy protection value by enabling sellers and buyers on the eBay platform to communicate with each other to effect a certain transaction requested by the buyer behind the relative anonymity of the user IDs and without revealing personal email addresses and other personal information. So that's one example, tangible example of something that eBay's doing. I think also eBay and similar companies are exploring approaches like tokenization and other privacy enhancing techniques, which both function as a data access security control to preserve anonymity, but as well enable the purposes of the processing activity to be achieved. Which is, I think, something Jaap-Henk was alluding to as well. And I think to build off those comments, just in terms of challenges, maybe it's first helpful to just articulate, even if obvious, some of the practical challenges, at least I perceive, in my opinion, with industry implementation of privacy by design and default. And it really boils down to process. You know, I'm a lawyer by trade. Lawyers aren't great at process. But when you work at large organizations, you realize large organizations need process, and being process-oriented thinking is very important. So, you know, a lot of the practical challenges involved are boiling these broad legal standards, which I think, you know, lawyers and academics and technologists working in the space understand those broad standards and agree with the approaches and those standards. But then, how do you put those into practice? So, you know, what to do, how to do it, and when. And one example that did come to mind is Agile. And I don't know if, you know, before going to a company, I didn't know what that was probably. But, you know, there's a lot of focus on working Agile and having things not be in a linear structure. And of course, lawyers want them to be in a linear structure. And, you know, this is an example, you know, if you send a lawyer a contract 8 times, they'll be like, you know, can I just review this one time? But, you know, working Agile and privacy by design and privacy by default, you have to figure out how to implement it within the bespoke processes of an organization. It has to work with how the large organization communicates, the culture of the organization, building it in at the right time with the right incentives. But one challenge is, maybe companies might not have all the answers at that point. They haven't determined the means of processing at that point. They don't know what the different options are, or what the budget might be, or what so I think, in terms of the practical application of placing it at the right place at the right time within a company's own bespoke processes is one, rather obvious, but I thought it might be useful just to articulate that challenge. And one solution, of course, is to sit with the tech teams all day, beside them, BFFs, and that would be a certain option that we'd all love to do, but might not be a practical option for companies of SMEs, and not every organization would have the resources to be able to enable that type of engagement on a second by second or day by day basis. Another piece I just thought would be useful to highlight is in terms of the broad legal standards, necessity and proportionality, data minimization, et cetera, and that not necessarily being instructive for technologists like Jaap-Henk to do the thing you need. So for the law team to come in and say, or the DPO to come in and say, here are the standards, do it. How to bridge those gaps between technologists and the legal standards themselves. And I think the role of PETs in having defined use cases, maybe having some whitelisting of particular PETs that within certain contexts or use cases that have been vetted, and say, hey, this might not be perfectly applied in every single factual scenario, but within these particular use cases, it would be something that would be a compliance tool that organizations, that data controllers can rely upon, because of course the data controller has these legal obligations and the onus is on the data controller to implement Article 25, Article 5 and the other legal requirements. But then having those steeped in practical examples, even if they're done by data processors or vendors, that provide some assurance as to the compliance of that particular tool, at least as applicable within certain scenarios.
Thank you very much. Those practical insights were really useful. So now I'm going to go to Marit. So from our research, DPAs have been more comfortable in implementing organizational measures rather than technical ones. And when they are actually talking about technical measures, they're more at ease in mentioning encryption or pseudonymization that are condoned in the GDPR. So do you think that there are underexplored issues or solutions that we could see in Europe when enforcing Article 25 of the GDPR?
Thank you for these questions. There were several there. Because I'm a computer scientist, I'd like to go more into detail for the unexplored sections, and let's dig into this discussion and solve everything. But first we have to understand how DPAs work and have to work. And so this is the question about are DPAs comfortable with something or not? Because it should not play a role whether they are comfortable with something or not, because they have to do their job. And indeed, there are two questions. One is about the expertise within the DPAs. Mostly triggered by law. Much of the staff has some legal background or administrative background. They're in almost all DPAs also technology people. Not always they have joined teams to do an investigation. Sometimes it's not necessary. Sometimes it would be preferable to combine that even more, or also to specialize in the technical field or in the legal field, which is now very challenging. It's challenging, of course, also for a company, but they know what they are doing. They are only focusing on one thing, and they know then, and of course there can be standardized solutions, how this can work. For DPAs, they should be able to investigate and form solutions for everything, so the decisions. And now the second thing is about the toolbox. What do we have? You can look into Article 58. This is about the investigative rights, but also about the measures. And many people think the fine. It's always the fine. You should set a fine, otherwise it's not a case. And no, there are even stronger possibilities, I think, because fine is usually something after the fact. Something has happened, but I'd like, and this is also already in the GDPR, to look more into the future, to see how should everything now be changed. But we will come to that probably later again. First, what about now these administrative decisions? We have to adhere, each member state has own laws, to our administrative law. This is not harmonized. This is a little bit tricky thing. And in Germany, it's very structured what we have to do, how to investigate a case, how to communicate with the controller, how to hold a hearing. Without a hearing, it must not happen to overstep that. How to finalize then a decision, usually after several communication letters or sometimes visits. Then potentially handling complaints. The controller says, no, that's not right, that's not the right case, or you did the legal reflection is not correct. Okay, you have to overthink that. And then potentially again going before court, which takes quite a long time. We suffered from one case for more than 10 years, going through the ladder over the instances in the case of Facebook fan pages. In the year 2010 and 11, we set 10 decisions on please deactivate this fan page because you cannot prove that it is compliant according to the old law. And we lost the cases in the first instances. So after 3 years then we had the chance to go to the federal court, and then this court said we have to ask the question to European Court of Justice, and then we went back and, well, finally we won. So after 10 years or more, we were able to enforce our decision to deactivate only, not to delete, deactivate a fan page. But before that, we were very, very much scrutinized. Like, did you do, there was not a complaint. There was a selection or right of the data controllers. Why this controller? Why not other controllers? So this was, we have to prove that is the right selection. Was it understandable what you said? So is it possible now to understand for the controller that what they have to do? There has been another case in Bavaria where they enforced to deactivate a dash cam in a car. But they did not give the version number and the model number of this dash cam, and they lost the case. The DPA was not able to enforce that because this was not determined as far as that was necessary, well, at least deemed by the Bavarian courts. So it's very stressful to do that. It takes months usually to prepare such a thing, even without going before a court. And now we see Article 25. I love Article 25, but it's really vague. It's abstract. And there are only a few words like encryption or like pseudonymization or something where it's really something where the courts also can read the text and understand, oh yes, the final decision of the DPA matches Article 25. Oh, this might be a case where they are right. I think it's really, we are at that level. And we should go beyond, of course. But we first have to do, perhaps, my background is northern Germany. We have the coast. We learn a lot from the Netherlands to understand how to protect our land against sea or wind, and that we don't lose our territory. So the islands, otherwise they are gone. I think data protection is a little bit similar here in Article 25. We have to first have some cornerstones and columns and pillars and some structure. And then we need this land reclamation, so really that we hold that. The courts give us good feedback if we are doing it in the right way. And they say, okay, this is now set. It's really not disputed anymore, and everybody can profit from that. Now it's stable. It's a stable foundation. But it's slow. It's a very slow progress. And probably we need both, and also none of your business and other cases and so on. So only that this is one of the mechanisms. Okay, I think on the underexplored areas, perhaps only one big thing. How to really do that, of course, this is very abstract, but also how to consider that many of the technologies are not easily solvable for only one player, like the data controller, because they depend on an infrastructure, on other controllers, on processors. And how to do that, because sometimes nobody seems to be responsible. Also, the state does not seem to take over responsibility. And this means that some of the very good solutions could not fly if there's no support in this direction. So this is really a limitation. It could be about attribute-based credentials, data minimization ideas in the identity field. It could be about sticky policies, expressing more. I see some good future for that because of other reasons. We may go into that later on. But if you ask me, are there underexplored areas? Mostly everything is underexplored in Article 25. I would promise, let's meet in 5 years again, then everything is... No, it will not be solved in 5 years' time. So we need to grow, but also, of course, react appropriately. And we need to know, and also the DPAs, what about the state of the art, the technologies, the solutions, the sometimes counterintuitive solutions. And so everybody has a job here to talk to DPAs and convince them the world is wider than only what is already there with encryption and pseudonymization. I definitely will do that.
Thank you very much. I think it's really important to see, your perspectives. Yes, you are in the forefront, so the DPAs.
Together with you.
So, yes.
Promise.
I think it's nice to hear these perspectives. So, Stefano, here you are. So, how should organizations that are involved in developing the next generation of technology, such as neurotransmitters, quantum computing, be thinking about data protection by design and by default? So, and can you share with us the technologies that you're following most recently?
Yes, sure. Thank you, first of all, for the panel, for the great question. That is a very big question, let me say. I think that starting from the general concepts of Article 25 and the evolutions and all the work you did here, that is, to me, a very good recognition of what happened from the very zero moment that was some years ago at this day. The point is, we growed. I feel that the community growth and learned a lot because at a certain extent, at the initial moment, all this data protection by design was intended as we need to be compliant. And was maybe just an answer of when do we need to be compliant. We need to be compliant in an early stage. And the growing that happened to me is an evolution into depthness and broadness of the concepts. Because the more I see implementation in practice of this concept, the more I see how effectiveness goes hands in hands with risk management. I was hearing before from Cameron the link with risk management. So the idea of trying to use design, that was also managed, by the way, cited, by the way, by Jaap-Henk, to sit and try to put on a piece of paper first, before going into implementation phase, what we want to achieve. That it's a very simple concept, let me say. It's not something that is, wow, unique, rocket science. It's literally what every computer science does. It's normal. But the point is, when a computer science, it's a simple management techniques. When do we need to sit together with a DPO, privacy expert, whomever, to check if what we are doing is compliant enough and efficient? To me, efficiency is the next level. So the idea of trying to find solutions that are not only very well working standards and practices, but that goes very much into the use case we are developing. In general, think for example to XR, extended reality, virtual reality, all this metaverse hype that we are seeing together now. I think, and we think also at EDPS, that it's important to see how the technology itself can be used to augment and to improve the effectiveness of respecting data protection principles and obligations. Because in these metaverse examples, can you imagine how efficient can be to have a fine-grained information notice or consent or whatever close to the artifacts that are processing your data at that specific moment? That is very different for having the beautiful information notice with millions of consent once of a time that you just, okay, next.
You said beautiful.
Exactly. That was the Italian way, beautiful, between brackets. So with these mindsets, the very important work that I think we are doing at the DPS is not only trying to see risks in the new technologies that are coming, like the one you cited, no? For example, the quantum computing or neurotransmitters and so on, but also to see how the same technology can be used as an advantage to the protection. And we did this in the Texonar project that maybe someone has already seen. That is a project where we try to stop, sit, and dedicate one moment to understand which are the technologies that we need to know today in order to be ready for tomorrow, for the next year and / 3 years in advance, in order to not have a strong line to take or a strong position on those technologies, but at least understand how much those technologies are risky, can generate risk, and how much those technology can be used in advance of data protection. In this sense, the idea is also to think about the future, Marit, as you said. It's very important, and to start developing this kind of mindset that is anticipatory in its sense. And also about risk. We were discussing last year about this concept that to me is very interesting, and I've seen in this year many evolution on the concept of risk sensing. So what we expect that might happen if those technologies are used in a wrong way today in order to be prepared for what might happen. This means that we can tailor requirements into the design today in order to be ready in case this might materialize. For sure, this is a very sophisticated approach. As you said, Cameron, not all the organization can follow this and should be tailored that much. Especially, I have some examples also to reply to the second part of your question, which are the technologies that we are following. No? One example is all the big field of AI at this moment is under, I think, Marit, big eyes of the data protection authorities. And for example, synthetic data or federated learning are the technologies that we are observing most for. For the one that don't know, synthetic data is a way to replicate the same statistical condition of a data set in a new one that in itself is a fake one. Pass me between brackets the term, but that replicates the statistical property of the components and the entity of the data set. While federated learning is a new way to train machine learning models insights and upload in service only the update to the models and not uploading all the data, personal or not, on a data center that is centrally managed. And on this artificial intelligence, I need to make a small marketing advice because we are having our explainability workshop in some days next week, on the 31st of May in Lyon, where we will try to also have this perspective. Data protection by design is a future-proof instrument. And one technology that to me is very important to mention in this discussion is CBDC, is central bank digital currency. It's a non-funny or over the hype topic, but it's something that is coming in many places around the world. And I think there we are observing how much that protection by design needs to be wired into the concepts of what is happening. Because, for example, imagine to have a central bank emitting a coin that it will be used by tomorrow by all the people that are paying and receiving payments in a certain jurisdiction. Can you imagine the effect of a wrong design choice on such an application, and how much useful it is to have an obligation that all the needed design in terms of privacy need to be done, validated, advised in advance, and the risk and the cost of having to substitute some decision at a later stage. That's it. Thank you.
Thank you very much.
Soft, yes, always.
I'm giving the positive note that it's all about a simple management technique.
From there on.
Of course. So I'm going to go to Jaap now to zoom in a little bit more on pets. So could you please explain to our audience about the concept of maturity of pets? So how can we measure maturity, and what connections can we make with Article 25 GDPR?
Thanks, Christina, for the question. And if I make any mistakes, Marit can correct me, because Marit and Maiko and I have been actually thinking about this. And I looked up the paper yesterday, and it was like already 8 years, almost 8 years ago. It's still good, apparently. Okay. Still useful, at least. I'm not going to say anything about good. But so what we try to do there, indeed, is look at if you want to apply a privacy-enhancing technology. And if you want to have information about which kind of technologies to apply, and especially if you want to know whether you can apply that in a business context, there's actually two things that are important, and both of them together define the maturity of this price enhancing technology. Of course, one is the technology readiness level that's already out there for many technologies. Maybe that is a bit too fine-grained. What we did is slightly rephrase that scale and basically saying of a technology whether this is at the ID stage and then all the way through a prototype stage until like production available right now kind of stage. And you've got to remember that in terms of like the technologies that we're talking about here, this is not like typical end products, but more like sort of like half-baked things that you plug into stuff that then in the end needs to work. So that was one of the reasons to look at readiness in this way. And then the second thing that we realized was that an important reason to apply PETs to begin with is that they need to be PETs. I mean, they're not supposed to be Ts, they have to be privacy enhancing Ts. And so they need to do something useful. And therefore, there was a second, basically, axis to this maturity, where you say that we also have to look at the quality. And the quality actually then consists of several different factors. And actually, we identified 9, namely the level of protection, the sort of trust assumptions that underlie the application of technology. I mean, the things that you have to satisfy in order to apply the technology to offer the protection to begin with. The side effects, what are the probably maybe unintended side effects of applying the technology, the reliability of the technology, how efficient is it? And I think Marit already mentioned that. Then the operability, the ease of use, so to speak. But like I said, this is a half-baked product, so it's not like end-user usability, but more like to what extent does this come with the manual for integration into the final end product? How well is it documented? Maintainability, and also an aspect of where documentation is relevant. Transferability, like, okay, I have this technology, but now at some point I'm going to change my underlying hardware, software stack. To what extent can I easily move that thing to this new environment? And then finally, the scope, like how broadly is the protection offered? So you see that the deceptively simple question, like, okay, let's talk about maturity. We all had this, and actually, when I still remember when writing this paper, like, come on, this is a no-brainer. This must be easy. This is not even a paper. I mean, this is going to be like 2 A4s, and then we're done. And we're like, no, it doesn't really work that way. So there's a surprising level of complexity behind that in order to express maturity. So that in answer to your question, and then actually I was struck with something by something that Stefano mentioned about the CBDC, where. I realized that there's many interesting developments being triggered by policy initiatives at the European level. I mean, we have the CBDC, the digital euro. We, of course, also have the update of the EDPS regulation. And what you see is that depending a bit on who is involved and at the table, for instance, the EDPS proposal, you do see a very clear attention being given to privacy properties, or even in the regulation itself. And of course, it has to be technology neutral. So the actual level of privacy protection being offered very much depends on the architecture reference framework that still has to be published in sufficient detail to say anything useful about it. And then it's unclear yet if you look at the CBDC. I mean, this is, and this is interesting because, like, if we just look at the technology itself, I still remember doing my PhD at CWI in Amsterdam, where David Schaum basically was there, and he found a DigiCash next door, and this was in the 90s. So there is very concrete technology out there to have a totally privacy-friendly, anonymous form of digital payment that could be a digital euro. But for some reason, this is not in the mindset of the people now thinking of the digital euro. And now this might be because it's still perceived as new, risky technology, but I would say it was there, it was built, it was mature in our scale. Mm-hmm. So then there's still this discussion, okay, again, the question like, how do you get this applied? Yeah. Mm-hmm. Thank you. Thank you very much. So I see how complex maturity is. Like I knew, but now
I got it even more. So thank you. Cameron, I want to focus on a different area now. So we could make very interesting connections between dark patterns and by default settings. And here pets can again play a crucial role. But this debate has not resulted in standardized solutions yet and is a bit underexplored. So what are your thoughts on that?
So I think, again, I would go towards this idea of the whitelist for, again, from an organizational standpoint of vendors. I mean, certainly I would think it would be to the vendor's benefit to be on the whitelist, and from a market standpoint. And, it would provide some concrete applications to examine rather than broad standards and then waiting until enforcement efforts against a data controller implementing a PET, or forcing every data controller to create their own PETs. And so I really would just encourage regulators and others to think about whether that's a possibility of a whitelist of some sort. And again, it's very much understood that the data controllers have the ultimate responsibility legally here, but perhaps it's just not as helpful as it could be if the vendor pets aren't compliant out of the box, And so from a data controller standpoint, in order to do the right thing plus fulfill your legal responsibility, you have to do something supplemental, or you have to try to nudge the vendor to create a bespoke version for you so that it works for you and is a compliance tool. And it's not often that easy to do. And the example that kind of comes to mind, I think because it's well trodden at this point, I'll put it into your minds too, is the cookie tool. So, in the end, recently the enforcement efforts from the CNIL and others, have taken what was a market practice and said, this is not sufficient, And a lot of the vendors, some controllers had their own cookie tools, but a lot of controllers use vendors' cookie tools. So if the tool itself doesn't have the buttons at the same level with the same font in the same color scheme, if it has links, I just question why such a product would exist if it's, de facto non-compliant. So I guess I'm suggesting that, in addition for the commitment from the data controller's role, some commitment from a non-data controller who may have quite a bit of market advantage if you can take a stand a little more on legal compliance and saying here, because I understand that the incentives might not be there for vendors to say, okay, our product is compliant in all of these different factual scenarios, and I understand how that will be difficult to do, but I do think the regulators can maybe come in and say, even if it's a short whitelist, we were able to say, these are pretty good. We'd be okay with this. Not in all contexts, of course. It's still your responsibility. It's still fact dependent with all the caveats. But it might be some middle ground there. At least it's some way to bridge the gap between technologists, law, regulators, and process-oriented approaches.
Thank you. Interesting to bring the industry standpoint and the vendors, so I think it's something we should be thinking about. So, Marit, as I said before, the preventive nature of Article 25 is highly contested. So, in light of this, and in light of the current developments on the AI world that we all know, do you think that this provision is particularly useful in order to act before concrete harm is caused because of AI systems?
So, of course, it's a kind of provocation to say that DPAs perhaps would not take a case because Article 25 is not preventive or so. If I read the text, it is preventive, obviously. A case can be preventive, although perhaps it's not the outcome of a fine. So if you read Article 83, then if there's no harm done, this will have an effect. So there might be the possibility without a person really where harm has been done, this may be different. And what we in Germany are often hesitating to apply Article 25. So if you get a complaint, it's like, do now something with Article 25 on this case. We'll probably say, no, first we look at, is there a lawful basis? Article 6, let's start with the beginning. And then we say, oh, perhaps this is more a data subject thing. because 1/3 is about legal basis is missing or wrong. 1/3 is about data subject rights information or so is not sufficient. And 1/3 is security. So how much is there now for Article 25 if we have already something where the courts are feeling well with where we can enforce it more easily? But of course, this is now, because it's quite young, Article 25, something which will grow. What about AI now? Of course, we are looking at the AI Act, and we are now involved in an own investigation on ChatGPT and other tools that are being used. And what we have is the GDPR. We don't have more. So we have to use what is there, and Article 25 is now one of the vehicles. Although, of course, to be honest, if we have the full AI risk system, then data protection is only a tiny part. It may be a strong part, but then we have other problems. If we enforce this strong part very strongly, which everybody expects from us, then we may accept, or perhaps even in not being conscious about all possible solutions, perhaps even ask for solutions that won't cover all needs. And this is a risk, again, if the DPAs alone, with their strong power of the GDPR, whether it's Article 25 or something else, if they use that, it might not be the best solution. We need to communicate with the people in youth protection, or copyright, or, of course, anti-discrimination. This is already quite near. Perhaps competition law, so antitrust. So probably we need more communication, and therefore we're looking forward to having the Artificial Intelligence Act. And what has happened in May, only in May, is something where the foundation models now are also reflected in a new proposed, from the Liebe Committee, proposed Article 28b. And there I find a lot which is about by design. So this will be probably more the blueprint we or other enforcing regulators can and will use, and it's much broader. And of course, I was asked, is it a good thing or not? Yes, in principle, yes. But if we look, for example, how much is the data protection impact assessment applied? We don't know, because we are not seeing the DPIAs. Only if something has happened, or for specific cases, or if they're not feeling safe with that, they ask us consultation, then we see that. But with the Article 28b, this thing, you can look it up, it's very nicely readable. Then there's a registry. So they have to register their models beforehand and putting in also information on their impact assessment. Of course, then it's totally different. If this stays, because it's only a proposal, it will be negotiated. If this is something now, then it will be in this kind of method stronger. And also it's being asked for standardization. So this will be perhaps a loophole, because first we need some standards, otherwise nobody knows how to do that. But of course, again, we can import that from the data protection perspective also for Article 25. So we want to join the discussion, but we are fully aware we have a toolbox that is not existent because the AI Act is not in place yet for other disciplines. But it wouldn't be it wouldn't be honest to think the AI problems are being solvable only with data protection. Of course, we will contribute to that.
Thank you. Very nice points on the AI Act. But yes, of course, we should remember that the GDPR is there, and it still applies when data protection is personal data is processed. So
for the risk, of course, it has to evolve, but both have to evolve.
Exactly. Thank you. Last but not least, Stefano, I would like to ask, what are the particularities of public authorities having to comply with data protection by design and by default? And very often you have to buy technology and services from private providers. So how do you deal with that?
Yes. When I joined the EDPS and I had to confront myself with the data protection compliance of a data protection authority, I had a moment like, no. Absolutely, your question covers that kind of loophole that I had to solve. No, but jokes apart, a data protection authority is a public organization, as any other public organization. We have all the normal structures that you can imagine that are in place, like the DPO, there's the risk management, the compliance function, the controls function. It's normal, no? It's a way an organization works. The point is that there's a big difference that frankly speaking, I discovered, and that is even more pressing than the fact of being supervised by a data protection authority of a data controller in the private sector, because the data controller has only one data protection authority in principle and, let's say, by the book, to comply with and to wait at the door on inspections and whatever situation might face. A data protection authority, as a public authority, is under another scrutiny that is the transparency obligation. So each and every citizen can come and see what we are doing, and it's right, it's stated by law, and so on and so forth. So this is a lot more complexity. It's adding a lot more complexity on these processes in general. Also, when you go to choose external providers for services, for sure, there are many services that are in-house, others that are provided from the external world. But this is the problem. We need to be always. We need to lead by example, and I'm citing here the title of the EDPS. The DPS way of working was some years ago, in the sense that each and everything that will happen will be somehow under the eyes of everyone. But in general, how to do in practice is always about the process that needs to be accountable and well documented, needs to be there ready for any of those kind of work and inspections that we receive from citizens. Let me call them inspection between brackets for sure. Also in choosing external providers or any service providers, it's very important to understand first how to build up the list of service providers that can be analyzed under the business requirements needs, and that list needs to have the data protection requirements as the first points. In general, it's something that we used to do, but in general, having an outside look at the world around us, I think we are very far from doing this. In my experience, I've seen data protection as one of the points in the list, to scrutinize possible outsourcers, but not as the main one that discriminates. If include the outsourcers in the list, that will be put under analysis for the business requirements. And I think there is a lot to work on this, especially putting together the Article 25 with the obligation about data controllers, data processors, and controllers, and so on.
Very interesting insights. Thank you very much. And with that, we are done with the 2 rounds of questions. And we have plenty of time, as I see, for a Q&A. So now I will open the floor to the audience. And do we have any questions? Yes. Yes, we can go there and then there.
Thanks. One advantage of sitting under the microphone is you get there first. My name is Clara. I'm from the Information Commissioner's Office. You touched upon regulatory guidance on pets, and in fact, we are a regulator who has produced guidance on pets. I think we were the first data protection authority to do so. I wondered, Cameron, if you could give some examples in practice of when eBay has looked at implementing privacy-enhancing technologies to meet Article 25, and/or maybe Marit could elaborate on when you would expect organizations to do so, to kind of bring some specifics to the discussion we've had today. Yeah. Thanks.
So I mentioned the member-to-member communication, the intermediate communication example, also the tokenization example. But we've also, and are continuing to look at the intersection with the certification regimes. I think 25.3, there's synergy there with those. And not to go back to the whitelist again, but those kind of seem like the same type of conceptual piece. But certainly if the regulators are producing their own pets and those are available to the public, then that's certainly a whitelist of some sort and very, very helpful. My concern would be that the regulators might not have enough resources to do it alone and to produce those alone. So I think it would take a village for other stakeholders to kind of contribute to those efforts and to support the regulators' efforts to keep engineering those and making them available to the public and to industry.
And on the question for me, is it whether they expect the controllers to do something with Article 25 or the DPAs? Okay, controllers, yes. We have some document sets, for example, where they, in the process of testing and releasing their software and doing the data protection impact assessment, that they are also being asked or asked themselves, is there a better solution? Are there alternatives? And some write then many alternatives that they, oh yes, but this is worse and so. Like if you want to give money if there's a procurement action, you also have to be a little bit broader and not only give money to one of the best possibilities, for example. On the other hand, there may be failure. And even so I got something where our data protection officer internally said, okay, this is the best solution. And said, no, it's not the best solution. We can minimize the data much more and we can do it totally different. So it cannot be prevented by our own means, but we recommend that you overlook a better solution, which means usually you have to talk and not only the same person says, okay, this is the best solution, everybody is nodding because it's now filled in, but really challenge that. Why is this the best thing? And so it was a survey, and we could do with a very reduced data set. And therefore, we first had to understand what was really being asked for, and so what wasn't not so easy to solve. And this can happen even for our professional people. Therefore, I have no solution to really identify the best solution, but at least thinking about it and saying something, but the risk is diminished, even perhaps if it's not the best solution. This, I think, we can already guarantee with this, if they fill it in honestly.
Good morning. Thank you so much for all the ideas that you share here with us. I'm very interested in this topic. My name is Maria. I'm a law professor from Brazil. And we are doing a research there that I think fits some of your concerns and give some data to identify what path I think we should apply in regulating pets. We are part of an open loop program, and we are trying to test a prototype of regulating pets in Brazil and Uruguay simultaneously. And we have 10 companies that are trying our prototype. And they have been answered for 10 weeks questions about how clear is the guidance, how the context. It's important to point it out what kind of pets is necessary. We're trying to find companies that works in different sectors with different kind of data, like fintechs and different sizes also. So companies that works with health data, and we are trying to with child also data. So the idea is to have with evidence some kind of recommendations in order to give some ideas for the regulation perspective, what could and not could function in this environment. And I have 2 questions. In fact, I have many questions, but I know that I cannot take all your time, and I would like to share a coffee after with you, if it is possible. I would like to ask you something like, what kind of question do you think we should do with the components in the last phase in order to give a good idea for you that are thinking about this kind of regulation or more stability to understand the Article 25? And the second one, I saw here that you are talking about difficult in translation. It means difficult in translation between lawyers and engineers, difficult in translation in DPAs and judiciary to understand which means which kind of obligation. And we have already did this diagnosis in our research about the difficulty to communicate between engineers and the DPA. That is the person that is answer also the question, the survey. But we didn't have enough time to do this with the judiciary. we don't have a lot of jurisprudence cases to make a standard and identify what kind of translation they can do it. So my first thing is if this authority is thinking about how give some guidance to how to interpret it, how is the limits we can do this and the criteria. This will be very helpful if you have criteria to use and to guide us. And thank you so much for all your research. And I'd like to say that your paper helped a lot for us to design the prototype and thinking. Thank you.
So may I take the question? Yeah, I think mainly it's about the guidances that are already there, guidelines from on Article 25 and little more interpretation of the EDPB, the European Data Protection Board, on anonymization, the old one, but I guess this year we will finalize the new one. But also about communicating what is there. And of course, it's not only about understanding this vague article, but also understanding the concept. And therefore, perhaps it's even better to have an approach that is not totally bound to European law, but compatible, because then we, of course, can rely on previous work. For example, the privacy patterns that are compliant with the GDPR, the work from Jaap-Henk, which is also published a lot. Kim, I'd like to point to you, the next pillar in the pink, yes. She has done much work and also very easily understandable for both lawyers and engineers on threat modeling in the field of risk, also anonymization and so. And of course also to our work on standard data protection. We have an abstract level, but also then being more concrete, and it's following the mechanisms that are very well known by engineers. Because ISO 27000 standards and our BSI, the security people, they have been trained to understand confidentiality, integrity, availability, and then we take them by the hand and say, but now the world is more complex, come with us, but what you have understood, this is also good here, and then we try to tell them the risk is different because it's also about fundamental rights. Really, you cannot insurance against this risk. But you can understand that something like access control now also helps you. There are some new mechanisms, and this is being worked out. Some part is already translated into English. But if you like pointers, drop me an email. Thanks.
There is another for everyone. That's about which question do you think we must ask the companies about the experience? They are trying to apply 7 kind of PETs, companies that didn't apply PETs before, and in different sizes. So we have a guidance how to do it, how to choose the PET, the level of maturity, and after the experience they have with costs and with different kind of communication perception between engineers and legal, and also why the company should apply using this kind of technology and costs to be compliant with our version of Article 25 in Brazil.
Let me try to take that. I think I personally, let me just fill in like what I would like to know.
Yes,
because,
this is idea.
Yeah, okay. What I would like to know is what the step before, like what is their, how do they get to the point that they realize that they need to apply a certain PET? And what is the decision process that led to a particular selection of a PET? That will be my question. And I'm looking forward to the answer. If you can ask that, and then...
I can talk with you after.
Yes, please.
Hello, René Mailleux, Open University Netherlands and part-time Data Protection Authority Netherlands. And I have a question that I think is most fitted to the regulators, but maybe everyone can see. It's not... sorry, yes. So, René Mailleux, Open University and part-time Data Protection Authority Netherlands. I have one question. I've looked at the case law and the decisions on Article 25, in particular with access requests. So maybe my thinking is very limited to that, but I want to ask if it's something more generic. So first of all, I saw that I don't ever almost see cases where Article 24 and 25 are really separated. So I went in to try to understand how do they operate different in law, and then when I went to the decisions, they were always kind of intermingled, and I couldn't really separate them. So I want to see from the perspective of an authority, do you see that you can really put them differently when you start to enforce? And then secondly, the way I saw those two together function is often when there was an individual infringement on an individual data subject right, then reference to Article 24 and 25 were often made to say, oh, there is here more a structural problem. So we have a complaint that is about one case. This is maybe bad, but maybe it was an accident, or maybe it was a small individual thing. And then we think in those things to decide, no, this actually shows that there wasn't appropriate technical and organizational means and or data protection by design. Is this how you envisage that system to work? And maybe then also, is that the protective function? In
I think the easy question is, the easy answer to your question is yes. Because 24 is driving the rest of the chapter, as Article 5 is driving the rest of that chapter, chapter 2, chapter 4. So always 24 then also plays a role with 25. Sometimes you write it down, sometimes you leave it out because... But also with 32, of course. 32 is also something which is refinement from Article 24. And okay, and on theory you could only do with 25 because everything is already inside, but nobody would understand why this is true. The other thing is, yes, the structural problems. These are the things that are regulated by Article 25, and therefore if it's not, I have a process to give access to information, but I failed to see your email. But in principle it works. Or I've seen your email, but I was in coma, so sorry. But this may not be so structural. But there may be something where they cannot find your data, where nobody knows who's responsible, nobody knows about this right. So this is really structural. And then it's not one case, it may be thousands or millions or so, nobody knows. It has to be solved, and then 25 would be one of the solutions because it drives everything which has, processes. The thinking in organizational, technical, but also processes or systematic structural things. Yeah.
Thank you.
Can I quickly follow up on that? Because that was something that I noticed when reading the report, that actually, I think all the cases in the report never only involve Article 25. It's always with reference to Article 5, which I found surprising. And shouldn't there be more push to trying to actually only point to Article 25, saying, look, there's a structural defect, or what is holding you back in order to do that?
Because it's so vague and abstract, and that the courts would stop that. Article 5 has another, that this is a high fine, right? Article 25 is the lower fine frame, so this has to be considered as well. But Article 25 points
that's a very wrong incentive structure than in GDPR.
It's also vague. So but this means that the stress for enforcing your fine, if you follow the high fine, will be much bigger, and it takes more months, If it's about changing the system because they now can delete their things or have the no pure process, this may be, and there was no real harm done or so, then it's easier to not have only the abstract things. But of course, Article 25 points to Article 5 as well. So this is, from the legal point of view, you can write it down. But only 25 is really rare because it's more difficult to argue. It's really, before a court. I'm thinking about the last instance, and usually there is more than only Article 25.
Yeah. Okay.
We see a sign.
Yeah.
Yes. I mean, if we can answer that in 1 minute, because we started 5 minutes later.
I'll compress it.
Yes, just 1 minute.
I'll compress it then because it's a nice segue from the other ones, 24, 25 going together. I mean, the GDPR, I have really to reschedule this, to reframe this. The GDPR was trying to address the imbalance between the data subject and the data controller, but now sometimes we observe an imbalance between the data controller and the data processor, where it's the data processor that holds the power and determines what TOMs are really implementable, and sometimes, through contractual mechanisms, boilerplates, etc. And this ties in with conversations we had in the first panel and the second panel do we need maybe some text specificity at some point, some nice catalogs of pets that clarify what the state of the art is to help those those data controllers that want to be compliant, to discriminate? Or maybe we need to rethink the architecture of the GDPR.
Marit.
Yes, thank you very much. And of course, you pointed out now something which is where's the difference between 24 and 25, because 25 does not address the processor. So this is really something where it's more difficult to do that. And it has something with implementation costs. So the abstract thing, Article 24, you have to do that, but perhaps there may be an excuse because of Article 25. So it's not totally the same, of course. But I think you get the last word. Yes, we want some technology, some ideas, some state-of-the-art refinements outside the GDPR, I think, so on top. Perhaps also for different sectors, where it's clear if you do that way, then you don't have to fear the regulators, because you're on the good side. Sometimes it's not so difficult, it's not so easy because of interpretability, but if it's a mechanism, it would be nice for those who want to adhere to the law, and that's 99%. And for the others, we could find out much easier. I'd also see more technologies where I can find this is now easier for us to investigate, to find that it's not compliant, and to have the proof of the court.
I just add really quickly that we already have areas of the law where products liability, consumer protection, where you put a certain product into an ecosystem and you're the manufacturer of the product. So that may already exist, but maybe we're just not connecting the two pieces. But I would wholeheartedly endorse the approach that you suggested.
Thank you very much.
Thank you very, very much to the audience and to the amazing panel. Thank you.